matters ongoing in court. So I feel like there's a bit of leeway in terms of just discussing whatever is going on in court and all that, yeah, and maybe alluding to some conclusions.
Okay, and we can definitely look at possible scenarios.
Yeah, I mean, those are questions that have also been raised by the very judges in court, where they're asking if we give you this relief, then what may happen and what might not happen. So, yeah, it's also open to the public to just interrogate.
So among these issues that were presented by the petitioners on day one, and a list of issues, IEBC Chairperson Affulate Bugatti should be ousted, and Affulate Bugatti has been very consistent in the petitions. He is a person of interest. He was the he's the chairperson of the IEBC, and of course the returning officer, the national returning officer of the presidential results, and of course a question of whether he should leave office. And then there was the respondents then saying that it would be a constitutional crisis, even create a lacuna. So if Affulate Bugatti, in the event that Affulate Bugatti is ousted from office and we have to go for a rerun, what happens then?
So I think that question should be answered from first the context of how can Affulate Bugatti lose his office.
Right.
Of course, there's by death, then there's a prescription by the Constitution of how he should be ousted. So, of course, then the court does not have that inherent jurisdiction to say that now we have found Chebukati culpable and he should be removed from office. There needs to be a process to be followed, which involves going through Parliament and all that. As we know right now, the President has not yet called the first sitting of Parliament. As it is tradition, the sitting President calls the first sitting of Parliament, that is within 30 days after they've been elected into office.
Right.
So effectively right now, God forbid, unless he dies, and we're trying to see how the impossibility of him being ousted. But nonetheless, then, if he is ousted, remember that the chairperson of the IEBC has to have qualifications similar to that of a Supreme Court judge. So then we'll now go back to that scenario of shortlisting and all that. But again, remember, another crisis is the president has limited powers as it is right now, because there's already a president-elect in court. And until the court pronounces itself, the president-elect continues to be president-elect. So it will be very interesting, because this is it's a novel experience within the Kenyan judicial system. And it will be very interesting to see how the judges interpret this and how we come to the conclusion of it.
Okay, and then what is the process of, say, reconstituting a new commission?
Of course.
And how long would it take? Because we'll have until November if we were to go for a rerun.
So remember, first of all, they have to gazette the committee or the commission or the team that will recruit this commission. Then after they are gazetted, then now they have to allow for applications. Then they have to shortlist. Then they have to do interviews. Then they have to send the recommended person to the president for appointment. But again, as I keep saying, it will be very hard to see, or it will be very interesting to see how this all pans out, because then the president would also be usurping his powers in a way, because remember, he does not have the power. During this period, he does not have the power to make new and fresh appointments and all that. So looking at timelines, I anticipate 6 to 8 months, which means if we were to go to that route, then you're talking about maybe mid-next year for elections. Yeah.
Okay. And you mentioned the president's powers at this time. He is a caretaker president at this moment as we wait for the swearing in or a rerun. Then what is he limited to? What can he do and what can't he do constitutionally?
Yeah, so the very first thing is on appointments. He cannot appoint new state officers. He literally cannot make any appointment at this point. But as president, of course, he's still commander-in-chief of the armed forces. He is still the president of the Republic of Kenya until the handing over happens. So there's a whole range of things he can do, can't do, but I may not have all of them off the top of my head. But the main and key thing that we normally see with the president is on appointments. So that was the very first thing. The Constitution went ahead and said that during this period you cannot make appointments, or you cannot seem to be firing people, because it's a transition period. This was meant to also cure the effect of let's say the president was supporting a candidate and the candidate loses, and the president is now cross or is now mad at some people, so he wants to maybe fire them. Or maybe the person wins and now the president is trying to reward people and such things. So these powers were sort of curtailed just to ensure that there's a smooth transition of power into the next government.
So does this then mean that it is merely impossible to break the commission at this moment?
Constitutionally, it looks quite impossible, but as again I say, a lot of these things we'll have to see how the Supreme Court first of all interprets this, and how, even looking at the questions that were being asked, and they were asking the petitioner specifically that, look, you're asking for a relief that we do declare Chebukati unfit to hold office and we remove him from office. What then would you prescribe as a measure to sort of sort that lacuna? Should it happen, or should we decide to pronounce ourselves on the same? And it would be very interesting to see how the petitioners answer that today, because it's neither here nor there. It's not cast on.
So this is what happens in a democracy. You just push and see possible scenarios.
Yeah, I mean, you could even hear from the respondents' answers. I mean, response yesterday. They were saying that the petitioners have just thrown everything they could, because they're saying the elections were done in a very bad manner, and they could not even stand the standard test of elections that have been done well. But then Githu Muigai, the former AG, was asking that in the courtroom there were a number of senators, a number of governors who were standing in for the petitioners, and he was simply asking that if then they feel like the election was so badly done, do they also still consider that they were validly elected, having been sworn in, especially for the governors? Yeah, so it would be very also interesting to just see how that pans out in court today.
Okay, and before I let Simba just take a look at what's happening across the trends, then the role of the Iebc chairperson, Affulate Bugatti, has also come in question. We saw the 7 petitioners actually saying he appointed himself as the national presiding officer. So what is the role of the Iebc chairperson constitutionally?
Yeah, I mean, I think you mean the national returning officer. Mm-hmm. Yeah, so first of all, I don't think he appointed himself, because the Supreme Court has pronounced itself a number of times, and a number of case law referring to him as the national returning officer. I think the big question that was being asked is that all returning officers had to be gazetted before the elections. And the big question by the bench was specifically, then why didn't he gazette himself as the national returning officer if he'd occupied that position, or if he thought he occupied that position? But let's remember that decisions of the Supreme Court to itself are only persuasive. This is what we call persuasive, I forget the term, but they're only persuasive. So they can opt to move away from past decisions. I remember 2013, 2017 decisions referred to the Chebukati and the chairperson of the Iebc as a national returning officer. So it would be very interesting to see if this time round they would say, no, a returning officer has to be gazetted. You did not gazette yourself, so you cannot purport to call yourself a returning officer. So that is upon
the judges to say whether they will continue to see it as they did in 2013 and 2017 as the national returning officer.
Yeah, it's a
or maybe base the argument on, say, if it was not gazetted, then maybe it is not so.
Yeah, I mean, the Constitution and the Elections Act do not call the chairperson national returning officer. There is no such position. However, the court is the one that has pronounced itself on that issue a number of times. So it will be very interesting to see if they now depart from that and say, no, as a national returning officer, the procedure for being a returning officer is that you have to be gazetted. Yeah, so we would want to see, even as the petitioners answer the questions and do their rejoinder today, it will be very interesting to see how they answer that.
Okay, and the dissenting commissioners, who are 4 in number, now known as the opaque 4, then what is the role of the commissioners in the IEBC?
I mean, the commissioners have a number of roles, but specifically in national elections, a commission is formed so as to enable the easy, smooth administration of elections in a country. So definitely they'd have varied rules, administrative-wise, in terms of procurement and all that, and in terms of making decisions that are coming before the commission as a commission. But remember, yesterday one thing that was coming out was the description of IEBC. Does IEBC as a term refer to the commission alone, or does it refer to IEBC staff, support staff, and all that? And what was coming out clearly from the William Ruto's team, that is Githu and the team, was that IEBC does not necessarily just refer to the commissioners. It also refers to the staff, because in the multiple articles of the Constitution, it says that the IEBC will announce the gubernatorial winner, it will announce the MP elect, right, and all that, yeah. But when you look at this closely, these are things being announced at the constituency level or the county tallying centers, things that are being announced by returning officers at that level, and having reference to their commission. So the commissioners, of course, sit at the top, and they'd be able to just give that strategic direction from our commission level, but then cascade down what has been given into junior staff and to all that.
So does the dissenting view hold any water?
The role of the commission in presidential elections specifically is just to verify, tally, and then the chairperson of the commission is supposed to answer those questions. And when we started the show, I remember Simba was asking that these other roles that they're given, are they not support roles that actually lead to proper verification and tallying of the elections? And I feel like those roles that they were assigned by the chairperson would necessarily be very important, because the chairperson cannot be seen to be the one briefing the media. Then again, he comes out and gives an update on the constituencies. Then right, he again has to deal with the welfare of the commissioners. So I think these were all roles that were necessary for the successful verification and tallying of all these results. Yeah. Okay,
Simba, let me throw it over to you. What are people saying, and do you have any questions for our guest?
Yes, I mean, a lot of things that came out yesterday. Now, remember, the AG was presenting at the Supreme Court yesterday. We also have IEBC advocates also presenting. Let me begin from what really caught the eyes of Kenyans yesterday. If you do know, for some hours yesterday, you guys saw that online trending, get over it. That was one from Mahat Suman, who is one of the advocates of IEBC, or talking about the IECT matters around that area. And he said, look, the 64.6% turnout announced by Chebukati was not based on the gazetted voter register. He completely said it was based on the reporting of the Kim's kids. Now, let me tell you how it started to get to this area. That one of the advocates then of Iebc, let me just get his name because it was really trending yesterday as well. He came in and said that out of all the Kim's kids that were then used to run the election on the 9th August, only 200 failed. In fact, he said if you look at that in percentage, then you have 99%. Then he came out and said, well, if you look at that, that is a success. Now, Mahat Saman really got the Kenyans talking yesterday when he said, look here, the 50+1 percentage that we're talking about here is the number of voters that have been recognized to vote. And they said, in 2017, the Supreme Court was quite clear on that, and it told all the advocates in court, please, if you're not happy with this, get over it. Yeah, that raised a lot of concerns at the Supreme Court yesterday, with a lot of advocates saying, well, we don't like the way you're ruling it, because then we might want to look into that percentile as well, because this sitting is a fresh sitting that may want to also look into that 50+1 percentile rule that was made in 2017. important questions that also got Kenyans talking, because some of the questions here that the Supreme Court judges were asking are the ones that also that got Kenyans talking. Number one, why did the live streaming of the presidential results stop? If you do remember, Nelima, majority of the media stations that were running the live streaming at one point or another stopped. Iebc itself on their portal that was at the Bomas of Kenya did stop as well. Was speaking to one of our reporters here who was at the Bomas, saying that at one particular time when they were all glued at that screen at the Bomas of Kenya, the results stopped as well. Now, on the commission as well, one of the judges did ask, and that was Philomena, who asked, indeed, when you're saying that the role of the commission is to oversight, what is oversight? Because exactly that is what they are complaining about, that indeed they were not given the responsibility to oversight. And then to AG, that is the Attorney General, there was this question that was asked as pertains to Affulate Bugatti, that indeed in 2010 you were part of the constitution making process and you came up with the returning officer's role, the national returning officer's role that gave us the commission chair, that is Affulate Bugatti. There was this question that was asked. It looks as if you all gave veto powers to our chair in a constitution that was supposed to remove powers from individuals. Those are the responses that we're going to say. Let me, Philip, maybe Nelima, the question that Philip should respond to now is, when we're talking about this oversighting and that rule for the 50+1% that was made in 2017, does it stand, or the court is going to go back again and say maybe another new rule for the 50+1%?
And of course, he is right here. Philip Kisaka, you can respond to that.
All right, thank you very much. So if I get Simba's first question is, again, I think I answered a bit of it, but you're talking about the court departing from its previous decisions. As I keep saying, that the Supreme Court has, it's called persuasive precedent. So it means that the court can actually depart from a previous position based on a new set, of facts that it has been given. So it would be very interesting to see how the petitioners, the respondents, the petitioners do their rejoinder today, and the respondents also, I think they have 30 minutes. The CJ did not confirm whether she added them the other 15 minutes that Gid was asking. But it would be very interesting to see from the arguments today if the court is sufficiently satisfied with the answers given. Because remember that each petition presents a new challenge to the court. But the 50%+1 is in the Constitution. So if you do not meet the 50%+1 threshold, then it is automatically goes back to a rerun, and that is pretty much direct and clear. Yep.
Okay. And from the petitions that were submitted, that is on the D1 of the hearing, of course, a lot of accusations from the Iebc servers to the conduct of the Iebc chair, Affulate Bugatti, and a whole list, the 50+1 question. Then at what point do we say we have a case or we don't? Because again, depending on how the respondents responded to the submissions by the petitioners, then what is the process of making the judgment by the 7-bench judge?
I mean, you could see that they came up with 9 issues for determination, ranging from technology, the 50%+1, and all that. So it is important to note that even one of these issues could actually make the case for the petitioners and force 1 or 2 of the reliefs to be given in favor of the petitioners. That is why you find that when you could see the petitioners were presenting them chronologically from number 1 to number 9, and the respondents similarly addressed each issue independently. We saw Mahat go into the numbers. He also went into the technology, and he seemed to really understand the technology behind this. So what the respondents are really doing is actually poking holes into each issue. That the technology, you say it failed, it did not fail. But should it have been construed to fail, this was not a digital election, it was a manual election. And so we should focus on it as a manual election because the voting was manual, the counting was manual. It is only the transmission element that was digital. And the Supreme Court has also pronounced itself before, saying that in as much as there is a digital element of transmission, should it fail, then the election cannot be construed to have also failed because, as the Constitution provided, this is a manual election and not a digital election as Okia Umtata would have wanted to put it and say that the drafters of the Constitution anticipated a digital election, and that is why they put the 14 days limit in terms of solving a presidential petition. Yeah.
Okay. And for the layman, a lot of people who are watching from their television, they're basing on the side that they're supporting, either the petitioners or the respondent's side. Then when they hear a lawyer give a good vocabulary or cite, very nice examples, Bible examples even, then people have the tendency to say we are winning that case. So what should the layman be understanding as they are watching this presidential petition?
They need to understand that the court is very well trained to look through and see through any mischief by counsel, so whether for the petitioners and the respondents. And that's why when, after the petitioner's case on, is it Wednesday, there was a frenzy, people were up in a frenzy on Twitter, and they were saying the judges will already rule in our favor because of those questions they asked, and we are winning this. And one faction thought that until the respondent's case was presented and questions were also asked, and then people realized that the bench is really actually out there to find the truth and not necessarily look like it is favoring or it is partisan towards one faction. So the bench would necessarily not be swayed by this English and all that. And you even could see Smoking Wanjala refer to Kyoko Kilukumi and ask him about the Solomonic wisdom. Right. That was a light moment at the Supreme Court. But you could see that, yes, they've taken this into account. However, then they're trying to remain with that independence that we anticipate that they operate within.
Okay, and when the seven-bench judge then retreats to deliberate and then come with a verdict that we are expecting on Monday, just give us a look of what it means to deliberate on a case like a presidential petition.
So maybe I'm not privy to that information because you see, also the bench at that level operates at its own within its own code of conduct, rules. They have how they sit, they have how they discuss, and I believe that each of them maybe has also been delegated an administrative duty within wherever they sit as a bench. So it would be very hard to say that when they go back and retire to chambers, they will sit like this and like that. Maybe they've also just split out rules.
Will they be sequestered? I watched a series called Sequestered.
I remember the series Sequestered. Probably not. This is not a jury. This is the judges. Mm-hmm. Probably they've also been assigned roles like the way Bugatti assigned other people roles that you'll do welfare, you'll do media briefing and all that. But they don't have those things. So it would be very hard to say that behind the scenes this is what they'd be doing. But I know they do a lot of consultation, a lot of research. I know they're well resourced in terms of researchers and all that, because the material also they have to go through is quite a lot. But we did see them refer to a bit of material here and there in their questioning. This just told us that they've actually read, and they're just not putting up a facade in front of the media. They've actually read through these affidavits. They've gone through video evidence that has been given to them. They've taken judicial notice. Judicial notice just means that the facts speak for them. So we don't have to present it. Everyone knows of things that happen around the election, the violence at Bomas and all that. So we'd just be keen to see the decision, and should there be a majority a majority and minority decision, then we'd want to also hear the dissenting opinions, because it's not obvious that all the seven will agree that this is the direction they're taking. We'd also have to see dissenting opinions either on 1, 2, or 3 issues here.
Okay, and there are critics who have argued that a 3-day hearing is very little time to make a judgment on a presidential election. What are your thoughts?
Yeah, as I alluded to it before, Okia Mtata also tried to bring out the same issue, and I think his wording, first of all, offended one of the judges, and he was asked to repeat, and that he had to be very smart when he was repeating. But then again, I tend to believe that having so many elements of digital aspects within the electoral process meant to have that transparency and that swiftness in terms of determining any dispute, because first of all, Form 34As at the polling station are final, and then these things are uploaded by the KIMS kits, and they move to the National Tallying Center, and they are also transmitted manually to the constituency returning officer. So it was anticipated that with this digital support in this whole process, then it would be easier or faster to sort it. I still feel like it is a short time, because you'd hear counsel saying that can we be given more time to respond to the questions, and which also brings me to another issue where when between a petitioner and a respondent, a petitioner has the opportunity to have a rejoinder, but the respondent then does not have that opportunity. Right. But what the court has done by now coming in down and into the matter, they've also created that space for respondents to respond. Not as a rejoinder, but to respond. Yesterday, when Gidu was asking for more time, I remember the Chief Justice was telling him that you don't have the right to respond. However, we've raised questions that we feel like you need to respond. And there are so many questions. So I thought 15 minutes was a bit absurd. I hope they'll be given the 30 minutes they asked for today morning. Yeah.
And in the event that the Iebc Chairperson of Affulate Bugatti's verdict, his pronouncement of William Ruto as president-elect, in case it is upheld by the court, then what are the options for the petitioners, especially the Martha Karua and, of course, Raila Odinga? What are their options? They could accept the verdict, but could they still pursue any legal action?
I mean, the Supreme Court is the apex court in the land. Mm-hmm. So their option, as Mahat Somani had said, is to accept and move on, because then the court has pronounced itself. And they've also reiterated over and over again that they believe in the rule of law, and they will accept what the decision of the Supreme Court is here. So my advice to them, and what I think is they should accept and move on. Should the court uphold the win of the president-elect, William Ruto.
And what about the East African Court of Justice? In 2017, Martha Karua, when she was vying for the Kirinyaga governor, and she, of course, went to court, and the win of Waiguru was upheld, and she went on to the East African Court of Justice, where she was actually awarded money when she filed a case against the government. So is the East African Court of Justice, is it a place that can be pursued in a presidential election?
Not really. The Constitution prescribes this thing, and it says that the presidential election disputes will be sorted out by the Supreme Court. Moving into the EACJ, that is the East African Court of Justice, you probably move in there if there are fundamental issues that move to speak to human rights. And you'd find that most people moving into the East African Court of Justice will do that, and they would frame their pleadings, so to speak, in a way that shows that human rights have been infringed. So probably, I don't know, I mean, Mike Sonko has tried to do that. I don't know under advice of which council, but he's also tried to move to the EACJ to say that his political rights have been infringed by being barred from running for governor in any county in Kenya. Yeah, but doing that would be a losing battle, because then the East African Court of Justice does not have jurisdiction to decide how we carry out our internal affairs in terms of elections and governance in the country.
So the Supreme Court then is final as far as the presidential election is concerned in Kenya?
Yeah, it's final, and I'll repeat that should the court declare President-elect William Ruto as duly elected, then they should just accept and move on, as they've done in 2013. I think they accepted, they didn't move on. By 2017, the court overturned the decision There was much dissatisfaction from the incumbent president, but then he had to accept, and we had to go back to the polls. Then the Raila team decided that they will not be running because Bugatti was still the one chairing the election, chairing the commission. And now it's 2022. I feel like they, as it has been tradition, you lose some, you win some. So if they win, well and good, we go back to elections. If they lose, then they need to accept, move on. We also need to see the president coming out and giving direction, because as we know, we've just seen him recently in Mombasa.
In public.
Yeah, in public after the election. So we would want to see him also coming out and as a good statesman to just say that, look, my favorite candidate did not win, William Ruto won, and I pledge and commit to a smooth transition of power. Yeah.
Okay. Simba, let me throw it back to you and just bring us up to speed with what is happening.
Yesterday, as we talk about this, by the way, it's just about 13 minutes to the top of the hour, and if anything that we've seen Mother Kome's court is that they've been quite spot on when it comes to meeting these specific times, and I highly doubt that Githumugai's application to be granted more time is going to see the light of the day, Nelima. Just going by the events that we have seen for the past 2 days at the Supreme Court. What we've seen, and I asked Philip this question when we were setting pace for these hearings, the quality of the presentations that we're going to say here. Now, Nelima, we did see these conversations online from the winning team and the losing team, where we did see Raila Odinga's team say, well, we did fail in terms of guarding our elections and the picking of the agents that we had put at these polling stations. Now, Eric Gumbo did actually come in yesterday saying, well, political agents are like, I suppose, I am told I have to stop now because of my mic. Nelima, can you take over as we look at my microphone?
Right. And Philip, maybe you can respond to what Simba is alluding to. And of course, the petitioners saying that maybe their only problem was not to guard their votes, and perhaps that is where then the respondents now took advantage of that.
So first of all, administratively, it is a duty and obligation of each party to select their own agents. And I think that is what Simba was also alluding to, where Gumbo was saying agents are like spouses. So you choose your own, and you need to trust whoever you choose. Remember, there are over 46,000 polling stations in Kenya. So if every time we were, agents were not to be chosen, and there was a dispute to arise, then the only way to verify that indeed these are actual, genuine results would have been to do maybe a recount. Now look at this in terms of budgets. So you've done an election, then someone is dissatisfied and they say recount. You'd be spending almost half again of the budgets in the elections to do a recount in order for you to establish whether votes were stolen or not. So having agents in polling stations just guarantees that the process at the polling station was final, and should there be any other issue in terms of maybe tallying or otherwise, then that can be easily sorted within the Supreme Court and within the 14 days granted to the Supreme Court to do that. Okay. Remember, 14 days is for the whole thing. They're only having 3 days of hearings and then 2 days to sit, retire, deliberate, and then Monday they need to give us their judgment. So many people say 14 days. I normally think it's 4 or 5 days they have. So having agents is very important, because then as they applied for that recount, we only did a recount in, I think, 41. Polling stations. If then there were no agents throughout the whole country, or if it wasn't a requirement, it would be very hard, because then it would have been you said, I said, you said, I said, and there would have been no way to prove this. But since there are agents in polling stations who sign off on these forms, who are even given copies of this Form 34A, carbonated copies, then it helps, and the process, it makes it more transparent, it makes it easier, it makes it even verifiable in terms of the public portal and the original 34A that is brought to the National Tiling Center. Yeah.
Okay. And the access to the servers, because servers have been a major topic of interest. how much access can petitioners have to the service? Because we saw the respondent saying that then if they need limited access, otherwise then it would be unusable. Should we go for a rerun?
Yeah, of course. Then,
how delicate is the server? Of
course, when we talk about servers, I'm not very well versed. Again, I'm not a very big ICT expert. However, when it comes to servers, then first of all, you talk about intellectual property rights. And this just means that the manufacturers of these servers and that whole electoral process management system have certain rights or certain ways that they have designed that system to operate. Remember that one example is like soda, Coca-Cola. We've been given this theory that it is only 2 people in the world who know the recipe, and when one dies, the other one is told and all that. So, like, put that